You have to appreciate the sheer audacity of it. You almost have to marvel at the level of arrogance required to look at a federal judge, a United States district judge, and tell him that his voice, his authority, and his direct orders simply evaporate the moment an airplane's wheels leave the tarmac. Because that is exactly what is happening right now in the courtroom of Judge James Boasberg. We are watching the Trump administration make a calculation that could very well end with senior officials facing criminal contempt charges. And why? Because they thought they found a loophole. They thought they could outsmart the judicial branch with a technicality so flimsy it wouldn't hold up in traffic court, let alone the D.C. Circuit. Here is the situation. Judge Boasberg gave a verbal order. He told the Department of Homeland Security, in no uncertain terms, to turn the planes around. We aren't talking about lost luggage here. We are talking about flights filled with migrants being rushed to El Salvador, specifically to a facility known as the Terrorism Confinement Center. The judge said stop. He said bring them back. And instead of hitting the brakes, the Trump administration hit the gas. And now that they've been caught, now that the flights have landed and the human beings on board have been processed into a nightmare scenario, the Trump DOJ has the nerve to walk into court and argue that because the written order, the piece of paper itself, wasn't signed until the planes were technically outside U.S. airspace, the judge's authority didn't count. They are essentially arguing that the executive branch is like a rebellious teenager. If they can just run out of the house fast enough, mom and dad's rules don't apply anymore. It is juvenile, it is dangerous, and frankly, it is a fatal mistake.
Because Judge Boasberg isn't playing their game. By relaunching this contempt investigation, he is signaling that the catch-me-if-you-can strategy of the Trump White House has hit a brick wall. He isn't interested in their GPS coordinates. He is interested in who gave the order to ignore him. He wants names. He wants to know exactly which official, was it Secretary Needham, was it a DOJ lawyer, decided that they were above the law. This is the fatal error. They assumed the court would be too slow, too timid, or too bogged down in bureaucracy to fight back. They assumed that once the deed was done, the court would just move on. They were wrong. Boasberg is now peeling back the layers of this decision, and he is forcing them to go on the record. He is stripping away the fog of war excuse and asking a simple binary question. Did you or did you not hear me say stop? If you are watching this, you need to understand that this isn't just about immigration policy anymore. It's about whether a court order is a command or a gentle suggestion. The Trump team bet on the latter, and now, as they scramble to file declarations and explain themselves by the December deadline, they are realizing they made the wrong bet. They didn't just annoy a judge, they challenged the structural integrity of the court itself, and the court is fighting back. To truly understand how dangerous this situation is, we have to stop looking at the headlines and start looking at the timeline. Because when you strip away the spin, what you find is a sequence of events that looks less like a legal strategy and more like a getaway driver trying to beat a red light.
Let's go back to March 15th, 2025. The Trump administration had just invoked the Alien Enemies Act of 1798. Yes, you heard that correctly. A law written when John Adams was president and we were worried about muskets, to bypass the entire immigration court system. They used this archaic wartime statute to round up Venezuelan nationals they claimed were members of the Tren de Aragua gang. Now, whether these individuals were actually gang members is a question for a court to decide. And that is exactly the point. In America, we have courts to determine guilt. We don't just take a politician's word for it and throw people onto a plane. But the Trump administration didn't want courts. They wanted speed. So, on the morning of March 15th, lawyers for these detainees rushed to federal court. They argued that the government was deporting people without a shred of due process. And at 9:40 a.m., Judge Boasberg issued a verbal temporary restraining order. He was explicit. He told the government lawyers to their faces that if any planes were in the air, they needed to be turned around. He didn't stutter. He didn't speak in riddles. He said, stop. And here is where the story turns from aggressive policy to criminal contempt. According to court filings that have just been released, the Department of Justice lawyers, specifically Deputy Attorney General Todd Blanche and Emil Bove, knew about this order. They were in communication with the Department of Homeland Security. They knew the judge had slammed the gavel. But instead of picking up the phone and calling the pilot, they picked up a law dictionary and started looking for loopholes. Their argument, the one they are legally standing on right now, is that because the planes had allegedly crossed the invisible line of U.S. territorial airspace by the time the written order was signed and uploaded to the docket, they were free to keep going. They're arguing that a judge's verbal command in a courtroom is legally worthless until the printer finishes the job. But wait, it gets worse. We now know, thanks to these filings, who actually made the final call. It wasn't a rogue pilot, it wasn't a middle-level bureaucrat, it was DHS Secretary Kristi Noem. The Department of Justice admits that Noem was advised by Blanche and Bouv that the order didn't apply to planes outside U.S. territory. Based on that advice that effectively told her she could ignore the clear intent of a federal judge, she gave the green light. She let those planes land in El Salvador, where the passengers were transferred to the Terrorism Confinement Center, a maximum security mega prison where human rights groups say torture is systemic. And if you think I am being hyperbolic about the administration's attitude, let me read you something that should make your blood run cold. A former DOJ attorney, Erez Revuni, has come forward as a whistleblower. He alleges that in the lead-up to these removals, Emil Bouv, who, by the way, has since been confirmed as a federal judge himself, didn't just suggest aggressive tactics. Revuni claims Bouv told his subordinates that if the courts tried to intervene, the administration should consider telling them to, and I quote, "fill W.U." He didn't say respectfully disagree. He didn't say file an immediate appeal. He allegedly said, tell them F you. This is the forensic evidence of a mindset. This is not a legal disagreement. It is a hostile takeover of the justice system. When you have high-ranking Justice Department officials allegedly instructing their teams to treat federal court orders with that level of contempt, you are no longer operating within the bounds of a democratic republic. You are operating as a rogue state. Judge Boasberg knows this. That is why he rejected their initial oops defense. That is why he found a probable cause that a crime had been committed, and that is why, despite the Department of Justice begging him to drop it, he has ordered every single official involved to submit a sworn declaration by December 5th, 2025. He is calling their bluff. He is forcing Kristi Noem, Todd Blanche, and Emil Bouv to put their airspace defense in writing under penalty of perjury. He is asking them to look the court in the eye and say, yes, we heard you tell us to stop, but we decided we knew better. And this brings us to the core of the forensic problem for the Trump team. Jurisdiction is not a game of tag. You are not safe because you touched base in international waters. The authority of a federal court extends to the parties in the lawsuit, not just the physical ground they are standing on. If the Secretary of Homeland Security is standing in Washington, D.C., she is subject to U.S. law, regardless of where her planes are flying. The Trump administration tried to play 4D chess with a federal judge, but they forgot the most basic rule of the game. When a judge tells you to stop, you stop. Now they're scrambling to explain why stop actually meant go faster. And honestly, it's pathetic. But if you think this is just about one rogue secretary or one bad legal take or one frantic morning in March, you are missing the forest for the trees. Because when you zoom out, you realize that what happened with these flights to El Salvador wasn't a mistake. It wasn't an administrative error. It was a prototype. This is not an isolated incident. It is a feature of the system they have built. We are witnessing the weaponization of a strategy that has been in the works for years. Act first, litigate later, and make the damage irreversible before the courts can catch up. Let's be honest about who we are dealing with. The people running the Department of Justice and the Department of Homeland Security right now are not institutionalists. They are not there to uphold the norms of the Justice Department. They are there because they passed a loyalty test. Look at the names involved here. Todd Blanche and Emil Bouv. These aren't just random government lawyers. These are the men who defended Donald Trump in his criminal trials. They were handpicked, moved from the defense table to the leadership of the DOJ, specifically because they view the law as a tool for the president, not a check on his power.
When you put the president's personal defense attorneys in charge of federal law enforcement, do not be surprised when they treat a federal judge's order like a nuisance rather than a command.
And this pattern of defiance goes back much further than 2025. We saw the prequel to this movie in 2017. Remember the travel ban? Remember the chaos at the airports? Lawyers were sitting on the floors of terminals, drafting habeas corpus petitions on their laptops, while Customs and Border Protection agents, acting on orders from the White House, ignored court orders to let people see counsel. They blocked access. They dragged their feet. They created facts on the ground while the judges were still putting on their robes. The difference now? They have gotten better at it. They have refined the process. In 2017, it was chaos. In 2025, it is calculated. Look at the tool they used to justify these deportations, the Alien Enemies Act of 1798. Do you think they just stumbled upon a law from the John Adams administration by accident? Do you think they were just blowing dust off old books in the library? No. They chose that specific statute for one terrifying reason. It was designed for wartime. It was designed for a time when the United States feared invasion by the French Empire. And crucially, it was written in a time before modern due process was fully understood. By invoking a 227-year-old law, they are attempting to argue that the courts have no jurisdiction at all. Their argument is that because the president has declared these migrants to be enemies under this ancient statute, the judicial branch is essentially fired. They are trying to create a legal black hole where the president is king and the judge is just a spectator.
This is why they ignored Judge Boasberg. In their worldview, the worldview of Stephen Miller, of Kristi Noem, of the entire unitary executive cult, the judge didn't have the right to speak in the first place. When they heard "turn the planes around," they didn't hear a binding order, they heard an illegitimate interference in the president's supreme authority. And honestly, it is gaslighting on an industrial scale. They claim they are the party of law and order. You hear it in every speech. But law and order to them does not mean following the rules, it means imposing their will. When the law serves them, they use it. When the law restricts them, like a judge telling them they can't ship people to a Salvadoran super prison without due process, they ignore it. They claim the airspace technicality was the reason, but we know that is a lie. If the planes had been on the ground in Texas, they would have found another excuse. They would have claimed the engine was already started. They would have claimed the door was already locked. The excuse changes, but the behavior is always the same. Steamroll the opposition, break the norms, and dare the institutions to do something about it. And that brings us to the most insidious part of this pattern. They rely on the fact that the courts are slow and the news cycle is fast. They know that by the time Judge Boasberg holds a hearing, by the time the appellate court rules, by the time the Supreme Court weighs in, those migrants will have been in that Salvadoran prison for months, maybe years. The damage is done. The lives are ruined. And even if the Trump administration eventually loses the case, they win the policy. They got the deportation numbers up. They sent the message.
This is the sovereign citizen tactic applied to the federal government. You see it in the way they handle congressional subpoenas. They ignore them. You see it in the way they handle record preservation. They delete them. And now you see it in the way they handle active court orders. They pretend they didn't hear them until the plane is over the Gulf of Mexico. They are betting that our system is too polite to punish them. They are betting that Judge Boasberg will write a sternly worded letter, maybe issue a fine that the taxpayers will pay, and everyone will move on. They are banking on the idea that there is no mechanism to hold a rogue executive branch accountable short of impeachment, which they know is a political impossibility. But here is where they might have miscalculated. By pushing this airspace theory, by essentially telling the DC Circuit that the executive branch is off limits the moment it steps outside, they are not just breaking a rule, they are trying to break the system. And judges, even conservative ones, even ones appointed by Republicans, tend to get very protective when you tell them they don't matter. This isn't politics anymore. This is a stress test for the Constitution. If they can ignore a court order because of a flight path, what happens when they ignore an order regarding an election? What happens when they ignore an order regarding free speech? If turn the plane around is optional, then every law is optional. And now we have to talk about where this leads. We have to stop treating the story like a legal drama that ends when the judge bangs his gavel and start treating it like the flashing red warning light that it actually is.
Because if you think this ends with 2 planes landing in El Salvador, you are not paying attention to the endgame.
Let's play this out. Let's imagine for a second that Judge Boasberg backs down. Let's imagine he accepts their flimsy airspace excuse or issues a slap-on-the-wrist fine that the Department of Justice pays out of a petty cash fund. What precedent does that set? It sets the precedent that the executive branch is effectively immune to judicial oversight as long as they move fast enough. It establishes a speed limit on the Constitution. It tells every future administration, and specifically this administration, that if you can physically execute an order before a judge can print a PDF, it's legal. Do you understand how terrifying that is? If they can ignore a court order to stop a deportation flight, what happens when the court orders them to produce a prisoner? They'll say, sorry, he's already been transferred to a black site. What happens when a court orders them to halt a purge of voter rolls? They'll say, sorry, the database has already been wiped. What happens when a court orders them to release funding for a program they hate? Sorry, the money has already been spent. This is the death of the checks and balances system by 1,000 cuts. It is the normalization of the idea that the president is not a co-equal branch of government, but a king who is occasionally annoyed by judges. And make no mistake, the Alien Enemies Act is not just a tool for today. It is a weapon for tomorrow. By successfully deploying a 1798 wartime statute against people who are not from a country we are at war with, and by ignoring the courts when they try to intervene, the Trump team is building a legal fortress where any action can be justified under the guise of national security or sovereign authority.
They are testing defenses. Like the velociraptors in Jurassic Park, they are throwing themselves against the electric fence to see where the weaknesses are. And right now, they have found a weakness. The courts operate on logic and procedure. The Trump administration operates on brute force and speed. And let's not forget the human cost here. We get so wrapped up in the legal theory, jurisdiction, airspace, writs of mandamus, that we forget what is happening on the ground. Human beings, fathers, brothers, sons, were loaded onto planes against a judge's order and flown to a prison in El Salvador that is effectively a dungeon. The Terrorism Confinement Center, CECOT, is a place designed to break people, and the Trump administration sent them there, knowing that once they landed, no U.S. judge could save them. That cruelty isn't a byproduct. It is the point. They want you to see that. They want the world to see that. They want to send a message that says, the American legal system cannot protect you from us. This is the terrifying reality of the future if this behavior goes unchecked. We are looking at a future where the Department of Justice functions as the president's personal law firm, where the Department of Homeland Security functions as his personal militia, and where the courts are reduced to a debating society that issues opinions nobody reads and orders nobody follows. So what happens next? All eyes are on December 5th, 2025. That is the deadline Judge Boasberg has set. By that date, the Trump administration must submit their sworn declarations. They have to put their names on the line. And this is the moment of truth.
Will they lie? Will they claim executive privilege? Will they try to throw a mid-level staffer under the bus to protect Secretary Noem or the White House? Or will they double down and tell the court again to its face that it has no power here? Judge Boasberg has a choice to make too. If he finds them in contempt, he has to be willing to use the full weight of his authority. We are talking about potential sanctions, potential disbarment for the lawyers involved, and yes, potentially even jail time for officials who willfully violated a court order. It sounds extreme, I know, but if the punishment for breaking the law is nothing, then there is no law. We are standing on a precipice. The guardrails of democracy aren't failing, they are being dismantled, bolt, by people who know exactly what they're doing. So here is my message to you. Don't look away. Do not let the complexity of legal filings or appellate procedures bore you into submission. That is what they are counting on. They want you to tune out, they want you to think this is just Washington noise. It's not noise. It's the sound of the door slamming shut on the rule of law.
If you care about living in a country where the president works for the people and not the other way around, you need to be paying attention to United States v. Doe. You need to be watching Judge Boasberg, and you need to be ready to make some noise of your own. Because if we let them turn the courts into a suggestion box, we won't recognize this country by the time they're finished with it. I'm Ethan Cole. Don't just watch. Stay angry, stay informed, and I'll see you next time.